Hello, everyone, and welcome to the second in the webinar series on the criminalization of homelessness hosted by the National Law Center on Homelessness and Poverty. Today's webinar is entitled Alternatives to Criminalization, Policies that Work to Sustainably End Homelessness. We will be recording this webinar, and it will be available along with a copy of the slides on our website at www.nlchp.org. Also, you will have an opportunity to submit questions in the text box, and if time allows, at the end of the webinar, we will be happy to take your questions, so please do send them in. We will also have a few short survey questions toward the end of the webinar series, and we'd really appreciate you answering those very brief questions to help us better tailor our content for you. Next slide, please. Today's presenters include myself. My name is Tristia Bauman. I'm a senior attorney at the National Law Center on Homelessness and Poverty. And also joining us today is John Pollock with the National Coalition for the Civil Right to Counsel. Next slide, please. Just a brief overview of what we discussed in our last webinar series. We talked about the Law Center's tracking of 187 cities across the country, both large and small, rural and urban, over the past 10 years to survey what laws it had on its books that criminally punish the life-sustaining activities of homeless people or civilly punish those same activities. We also reviewed practices that displaced homeless people from public space despite a lack of any alternative place for them to exist. And we have just here a slide showing the relative increase over the past 10 years. And what we've seen are dramatic rises in laws that punish the existence of homeless people in public spaces. Next slide, please. And while last time we described the problem, we did not talk a lot about why criminalization strategies, while popular, simply do not work. In fact, they are the least effective strategy for addressing homelessness. And why is that? Well, first, there are collateral consequences of criminal convictions that can affect employment, housing, and public benefits. When someone is arrested for being in a public space, particularly when they have no other alternatives, they may be incarcerated. And while it's widely believed that homeless people are not employed, the data suggests otherwise. In fact, there are large proportions of homeless people who are employed, and if incarcerated, could risk losing their jobs. In addition, if a homeless person wished to challenge the underlying offense, that would require them to attend multiple court hearings, again, risking loss of their job. Moreover, civil punishments that issue tickets homeless people cannot afford may also result in future incarceration for failure to pay or for failure to appear in court to explain why there has been non-payment. Also, employment opportunities are restricted for people who are issued tickets that they cannot afford to pay. For example, driver's licenses are commonly suspended as a result of unpaid tickets, and that can restrict the number of job opportunities available to a homeless person. Even if someone is not employed currently, to obtain future employment can be difficult when someone has a conviction on their record. Similarly, with housing opportunities are foreclosed by enforcement of criminalization policies. Even public housing, federally subsidized housing programs can create lifetime eligibility bars for people who have convictions on their record. And this can be convictions even for minor offenses. While federal law prescribes a very narrow set of crimes that require that someone be ineligible for a lifetime, local public housing authorities that administer federally subsidized housing programs have wide discretion to determine what they will accept into their housing programming and what they will not. And while the Department of Housing and Urban Development has encouraged PHAs or public housing authorities to use their discretion to be inclusive of people who have been incarcerated. Not all public housing authorities do that. And in fact, even a simple misdemeanor can create a long-term or even lifetime barrier to ever receiving federal housing subsidies. In addition, conviction on someone's record can make them easily passed over for rental housing in the private market as well. In addition, public benefits can be affected by criminalization of homelessness. For example, someone who's incarcerated has their SSI benefits suspended, and SSI is granted as a cash benefit to people who have qualifying disabilities. If someone is incarcerated for a period of a year or longer, then their SSI benefits are terminated and they have to reapply in order to receive them. The result of these collateral consequences means that homeless people have a difficult time earning an income through employment or public benefits, or securing the very housing that they need to escape homelessness. And in that way, criminalization worsens the problem of homelessness. Also, it can interfere with service relationships when homeless people are moved from place to place, even if only under a threat of arrest. It can make them more difficult to find, and it can create barriers to their ability to access public transportation or access the service centers where they receive the services that they need. It also creates a culture of distrust between homeless people and police, which can not only create harm in that relationship, but can flow to other relationships between homeless people and governmental actors, which can undermine even well-meaning outreach efforts. Finally, criminalization worsens the problem of homelessness because it wastes taxpayer dollars on a strategy that does not work at the expense of investment in strategies that do. Next slide, please. So briefly, let's talk about the cost of homelessness. Criminalizing homelessness costs more than solving it with housing. The U.S. Interagency Council on Homelessness estimates that chronic homelessness costs about $30,000 to $50,000 per person each year. And contributing to those very high costs is the cost of cycling people through the very expensive criminal justice system and housing them temporarily in jails. Also, people who live on the streets are more susceptible to medical illnesses and otherwise require urgent medical care, thus increasing the likelihood that they will utilize very expensive emergency rooms. And also there are costs associated with conducting homeless sweeps, sometimes called cleanups of areas where homeless people have been camping, but without a plan to relocate people to housing or someplace where they may lawfully exist long term. In the absence of any alternative place to be, homeless encampments will pop up again, thus requiring the city again to invest in a sweep. None of those activities address the underlying causes of homelessness, and they do not effectively even treat homelessness's symptoms. Housing, on the other hand, ends homelessness. And the good news is that not only is it more effective in the long term at ending homelessness, but it's also more cost effective than criminalizing it. And research has shown that permanent housing is even more cost effective than providing emergency shelter or transitional housing that's usually time limited to a period of 2 years. One city or one state that has experienced tremendous cost savings and reduction in homelessness is Utah, particularly Salt Lake City in Utah. In 2005, a statewide effort to enact a Housing First program, Housing First meaning quickly pairing homeless people with housing without any unnecessary barriers before they could move into that housing, like, for example, requiring sobriety or mandatory compliance with services, has produced fantastic results for the state. In fact, they have experienced a 91% reduction in chronic homelessness since 2005. In addition to that very impressive reduction of visible homelessness, they have saved approximately $11,000 per person each year, simply by housing. Next slide, please. And it's not just Utah. In the report, we note a number of cost studies that have similarly found that housing is less expensive and more effective at ending homelessness than any alternative strategy. In Central Florida, 2014 analysis by Creative Housing Solutions found that whereas permanent housing and case managers would cost the area, which includes the city of Orlando, Florida, about $10,000 per person per year, that was $21,000 less than they were currently spending. And it was estimated that taxpayers would benefit with $149 million tax dollar savings over the course of 10 years simply by housing homeless people rather than attempting to shelter them, leave them on the streets, or criminalize homelessness. Similarly, a 2009 study in Seattle, Washington, on the other side of the country, found in a study by the Journal of the American Medical Association that housing homeless people resulted in a 60% decrease in costs per person after 1 year in housing. And indeed, what the study found is that benefits accrue the longer someone is kept into housing, again speaking to the desirability of cost effectiveness, desirability of permanent housing as opposed to any other type of housing intervention. Massachusetts also had a recent study by the Massachusetts Housing and Shelter Alliance of its Housing First programming and found that an average of just over $9,000 per formerly homeless person each year was found once someone was provided housing. And all of these studies account for the cost of housing and the cost of these supportive services, which can include case managers, mental health professionals, substance abuse professionals. All of those services that are necessary to help someone maintain stable housing. The Massachusetts study also noticed better outcomes for homeless people over time, less engagement with expensive crisis systems, medical systems, and of course the criminal justice system, but also overall well-being increased, and people were enabled to become productive, self-sufficient members of society. Next slide, please. So knowing that housing ends homelessness and it does it more cheaply than criminalizing homelessness, the Law Center put together a number of policy recommendations aimed at ending criminalization of homelessness and promoting access to permanent affordable housing. And so we will talk now about a few of the key policy recommendations. First, a policy recommendation is to simply end the criminalization of homelessness. It does not work, it's ineffective, it's expensive, it's often unconstitutional, as we discussed in our last webinar, and it will not produce the results that communities need, which is to end visible homelessness. So to achieve the goal of ending criminalization of homelessness, first, it is recommended that cities repeal and defund criminalization laws and practices. This means taking those laws off the books and ceasing to invest in criminalization practices, like, for example, ticketing homeless people, arresting them, or conducting sweeps that merely push them from one part of the city to another. To reform criminalization policies may also implicate a need to improve police training and protocols. And an example of a successful police training program that's operating is one in Washington, D.C., where the Washington Legal Clinic for the Homeless has, for the past 15 years, engaged in a very well-received and popular training program of the Metropolitan Police Department that they call their Homelessness 101 series. It's a 2-hour clinic. It informs police about the constitutional bounds of their use of police power. And in addition to it being something that has really benefited both parties as reflected by the successful relationship over 15 years, it also has resulted in fewer criminalization practices in a major metropolitan city like the District of Columbia. In addition, to end the criminalization of homelessness, it's important to eliminate those revenue-generating incentives to criminalize. For example, it's important to eliminate arrest quotas. In Albuquerque, New Mexico, for example, it was recently found that police were encouraged to arrest at least 5 panhandlers a month. That type of quota system creates an incentive for police to target poor and homeless people for otherwise harmless activity. So eliminating those quotas is important. Also, we know that some localities issue fines and fees as a revenue-generating feature for the local government. And certainly that was an issue in Ferguson, Missouri. So it is important that fines and fees, when instituted, are not done with the idea that they will be part of a revenue-generating stream, because again, it creates a perverse incentive to over-police and over-criminalize already vulnerable populations. Also, it is important for local communities to look at what discretion judges have to waive fines and fees on behalf of people who are indigent and cannot reasonably afford to pay. There are a couple of examples of communities that have also voluntarily ceased to engage in criminalization and ordinance enforcement. You heard from the representative of Syracuse, New York, in our last webinar talking about the success of the city in eliminating veteran homelessness and reducing overall homelessness without using criminalization strategies, and indeed employing police to be part of the solution and constructively building upon the relationship that police will naturally have with people who live out in public spaces. And another example is in Madison, Wisconsin, where after the Norton v. Springfield panhandling decision was handed down, the ACLU of Wisconsin wrote to the city advising of their concerns about the constitutionality of Madison's panhandling law, and the city attorney issued a voluntarily issued a moratorium on all panhandling arrests in the city. And we've seen other activities similar to that across the country. Next slide, please. It also is critical in an era where there are not enough housing units and too few shelter spaces to meet the needs of homeless people for cities to determine whether they can develop an emergency encampment versus a permanent tent city. So quickly, what am I referring to when I talk about an emergency encampment versus a permanent tent city? An emergency encampment can be a critical part of the solution whereby a locality designates a particular area of land where homeless people who are not able to access shelter or housing in the interim are temporarily able to lawfully exist with their belongings, with their partners, with their pets, and to receive necessary services like basic sanitation, water, toilet services, while long-term constructive solutions are pursued. To develop such an emergency encampment, it's important that the idea behind it not be that people permanently live in the encampment, nor that the encampment permanently exists in a given community. Instead, it is a city's emergency intervention to provide a single place, at least a single place, where homeless people may receive the services that they need, can lawfully remain without being pushed around the city, and be connected directly with the permanent housing that cities should be investing in the long term in order to save themselves money and also to end homelessness. To address encampments generally, it's necessary to develop constructive encampment policies. And we talked in the last webinar a bit about the U.S. Interagency Council on Homelessness guidance on ending encampments for people living in them. And just again, to note some of the key recommendations for policies related to encampments that are highlighted in that guidance that can and should be considered by all localities. One, ensuring that there's adequate time to plan a cleanup so that people are not forcibly removed from one area of the city only to be encouraged to establish an encampment somewhere else for lack of any alternative place to be. It's important to collaborate across stakeholder groups so that the expertise of all, information collected by all, and the resources available to all can be maximized to the benefit of the homeless campers as well as the city at large. A necessity of meaningful outreach and engagement, meaning constant outreach and engagement that isn't just contact, but that is paired with resources that can be immediately offered to homeless people to their benefit, like, for example, offering them permanent housing or offering them storage of their belongings over the long term, or offering them a lawful place where they can live day after day. And it's important to have low barrier paths to connecting people with permanent housing opportunities in the community. An example of a city that has a constructive encampment policy is Indianapolis, Indiana. Few key features of the Indianapolis policy: it does provide some advance notice before a sweep can be conducted, in its case 15 days notice. The city will store the personal belongings for homeless people for a period of up to 60 days and provides a method for obtaining property that has been stored. And most importantly, it restrains the city from being able to evict homeless people from an encampment unless there's an adequate housing alternative available to them. Next slide, please. And the Indianapolis, Indiana policy has been recommended by the National League of Cities as a model policy. And I'd encourage everyone who's looking at developing an encampment policy to look at what Indianapolis has on its books and use that as a model. There also are other types of legislation that can help end the criminalization of homelessness, and there is a role for the state to play. One of the things that we know is a reality for small governments is that they do not have the resources now to house all homeless people within their city limits. And also, if they were to create the services and housing in their city, when the neighboring city does not engage in similar policies, it doesn't actually sustainably end homelessness within their community. And instead, there's fear that it might, in fact, attract people from cities who are not similarly stepping up. Somewhat relatedly, there is a concern that cities who wish to use criminalization strategies to, in effect, chase homeless people out of their communities will engage in what we call a race to the bottom, whereby every city is writing their laws and enforcing them so aggressively such as to be the least hospitable place in an area for homeless people, with the desire being that homeless people are chased from one community to the next to the next. And that begs for a regional or larger response to criminalization. So one state law that can help end this race to the bottom is a model that will be pending in 3 different states in 2017, and that has already been considered in these same 3 states in prior legislatures, and that is the Right to Rest Act. It will be considered in California, Oregon, and Colorado in 2017. And what that act does is prohibits localities from criminalizing acts of rest when there are no adequate alternatives available to people in those communities. The advocacy work on that state-level legislation has been spearheaded by the Western Regional Advocacy Project. You can come to the Law Center's website for more information about the Right to Rest Act, and also you should check out the Western Regional Advocacy Project's website and their member organization websites for more information about the Right to Rest Act, and also see how your organization or how you individually might help support what really would be groundbreaking state-level legislation. Similar to the Right to Rest Act, though distinct from it, are what have been called Homeless Bill of Rights that were enacted beginning in 2012 in the state of Rhode Island, and that have since then been enacted in both Connecticut and Illinois. While those laws do not directly address the criminalization of homelessness, the laws that have been enacted in those states do provide protections that implicate the criminalization of homelessness. For example, the Homeless Bill of Rights in Rhode Island, Connecticut, and Illinois guarantee homeless people the right to move freely in public spaces as anyone else, which can help to eliminate some of the harassment and move-on orders that homeless people are commonly subject to for simply sitting on a park bench, for example, under sit-lie ordinances or under loitering ordinances. It also guarantees homeless people equal treatment by government agencies, and that is critically important because as the legal infrastructure stands now, homelessness is not a protected status. Next slide, please. Beyond just developing additional affordable housing, it's important that homeless people and people who are marginally housed and vulnerable to homelessness not be subject to unjust evictions or other practices that may cause them to lose the affordable housing that they have. We will highlight just a couple of options that all state and cities can consider in order to eliminate unjust evictions. And one is to protect renters in foreclosed properties. The foreclosure crisis really began in 2007, 2008, and there is wide-scale belief that the crisis has ended. And while that's true in some areas, it's certainly not the case in others. The former federal law protecting tenants at foreclosure act has expired and expired in 2014, meaning that there is no longer any uniform protection available to renters in foreclosed properties. Thus, that leaves state and local laws as the only laws that would protect someone in that situation. And while about half of the states have enacted some additional protections for renters in foreclosed properties, around half have not. And in addition, only a small handful of states have enacted laws that were as robust as the now expired Protecting Tenants at Foreclosure Act. The reason why it's important to have legislation that is specifically directed to this group of renters is because under current state law in many places across the country, renters in foreclosed properties, even those that have been paying their rent on time, have been abiding by the terms of their lease, and who may have no knowledge of the foreclosure process being conducted as it relates to their rental home, can be subject to very swift and legal evictions, sometimes with no notice or very little notice, just a few days' notice. This can be, of course, a problem and create housing instability for people who are living in foreclosed properties. It also can result in the termination of their otherwise valid lease agreement and create an eviction on a person's record, which can make it difficult to impossible for them to rent units in the private market in the future. So incorporating laws both locally and at the state level that provide sufficient advance notice once foreclosure action has occurred that could affect the tenancy of someone in that property, ensuring that bona fide lease agreements survive the foreclosure process for the duration of the lease agreement, and providing some mechanism whereby people who have lived in those properties and have been subject to swift eviction actions can expunge those evictions from their records, are all steps that can be taken to improve housing stability and security of tenure for marginally housed populations. Similarly, and even more broadly, just cause eviction laws can be enacted and should be enacted by city and state governments. What do I mean when I refer to a just cause eviction law? I'm referring to a law that requires there to be some good cause or just cause before someone can be evicted from a rental home. Now, the way that the laws that have been enacted in this category and that are being proposed as it relates to just cause eviction laws really vary, but ideally this would be one that would allow, of course, a landlord to evict when, for example, someone stops paying rent, but would not allow a landlord to evict someone upon no cause after the expiration of their lease agreement, or if they have a month-to-month lease agreement. The benefit of such a law is that someone who has otherwise been a good tenant, has an initial, let's say, 1-year written lease agreement that has expired, and they continue to pay rent and continue to abide by the terms of their lease, should, without there being present any good cause to otherwise remove them from their home, should be able to be secure in the tenure of that home and continue to rent. What this does is provide basic protection for landlords to ensure that they have good renters, but protects renters from being kicked out of an affordable unit so that the landlord can then raise the rents and rent to someone of higher income. And in that way, it can help keep the affordable housing stock that already exists in a given community. But these laws are not all that meaningful when a person does not have the legal counsel to help them navigate the court process and help them raise defenses to unjust evictions. And that's why it's very critical to have a right to counsel. And at this point, I will turn it over to John Pollock, who will talk about his work to establish a legal right to counsel in housing cases.
Thank you. Can you see my PowerPoint at this point?
Yes, I can see it. It looks like it could go to slideshow view.
Okay, give me just a moment. Okay, do you see it now in slideshow view? Is it now in slideshow view?
It's not. We can see the slides though. So if you'd like to proceed just as it appears there, everyone can see what you are referring to. But it also shows your notes and the PowerPoint.
Okay, that's fine. There aren't any notes, so I'll just be able to focus on the main screen. So thank you. My name is John Pollock. I'm the coordinator of the National Coalition for a Civil Right to Counsel. And I'm really pleased to be able to talk about how the right to counsel fits in as a policy, a good policy for ending the criminalization of homelessness. As Tristia was just saying, they're really, the best laws in the country essentially don't amount to much if you don't have the right to be able to enforce them. So the work that we do basically is around creating that enforcement mechanism. Just a quick word about the coalition. We are about 300 participants in 38 different states. We basically work on a number of different basic human needs areas, of which housing is one extremely important one. In fact, the American Bar Association recommended in 2006 that all jurisdictions provide a right to counsel in basic human needs cases, and it specifically listed housing as one of those basic human needs areas. Why a right to counsel in housing cases is important, you heard certainly the enforcement mechanism. It's a basic human need. What a person stands to lose in a housing case is multi-layered, obviously not just their housing, but all the collateral consequences of losing their housing, the effects on their children, the effects on their employment, and so on and so forth. But there's also the fact that we have significant data showing that when people have counsel in housing cases, specifically in housing cases, that they do dramatically better than they do when they're on their own. In fact, they do dramatically better even than when they get limited assistance from an attorney. In other words, when they have an attorney to go with them to court to stand with them in the eviction proceeding, they do better than when an attorney just gives them advice before the hearing and sort of guides them in general but doesn't actually appear with them. People who get an attorney to go to court with them do anywhere from 2 times better to 6 times or 10 times better than people who go to court by themselves. So we know empirically that counsel makes a big difference. There's also the fact that in housing cases, there is a dramatic imbalance of power. Landlords across the country are almost always represented, whereas tenants are very rarely represented. The figure we use is often 90-90, meaning that landlords are represented 90% of the time and tenants are unrepresented 90% of the time. And when you have an imbalance of power like that, it basically creates systemic inequality. It causes the proceedings themselves to lack any sort of fundamental fairness and instead become what is often called a cattle call, where courts dispose of hundreds of cases very quickly and basically just follow what the landlord's attorney tells them to do. So this basically restores equity to the proceedings. It also makes people believe that the judicial system is there for them, which is extremely important. It restores faith in it. And there are significant financial benefits of providing counsel that basically when we stop, and this was alluded to in the earlier part of the presentation, but when we stop these negative consequences, the homelessness, the incarceration that happens with criminalization and so on, those have very significant costs that are much more significant than would have been to provide a lawyer at the outset. Lawyers can avoid a lot of those external costs, especially because they're so effective at stopping evictions, not just by actually always necessarily keeping the person in that unit, but in some cases helping that person transition to a more stable housing system. That's a thing that an attorney can do. There are many roles that an attorney plays besides just going to court. They can also help that person apply for public benefits. They can help that person search for alternative housing. They can overcome potential public housing bans that the person may have encountered, and so on. So there's sort of a package that a person can do if they're provided a lawyer as of right. So just a quick note about why is it that we say you need a right? It's because basically when you leave people to basically, when you leave judges to basically decide on a case-by-case basis whether people get counsel, what we've seen time and time again is that counsel doesn't get appointed. The litigants themselves, tenants and homeowners, are not able to articulate their own reasons sufficiently for why they need counsel. They're not able to explain the merits of their case. They're not always able to present a coherent factual pattern of their story, and judges will often just say, well, I don't think a lawyer would have changed this result, so I'm not going to appoint one. There are also questions of judicial bias. What is meritorious for one judge is not for another. Some judges may have an anti-poor bias, where they look upon certain people, particularly people who are unhoused, with a certain skepticism. So there are very solid reasons that have been written about extensively about why it should be a right and not a case-by-case. I'm not going to talk a lot about litigation, except to say that litigation is one of the ways that it's being attempted to institute a right to counsel. It's not really the main way right now, as we'll talk about in a minute, but it has been explored. There are a lot of different claims out there for how to get to a right to counsel in housing cases. there are a lot of questions, which I'm just flashing up on the screen right now, that we have to answer in determining whether or not litigation is the right way to go. The question of whether it's a better policy to go to your legislature or try to bring lawsuit, there are a lot of questions that many people have thought about. Some of them are on the screen here. So anyway, because I want to focus more on the policy end of things, I just wanted to flash out there that it's not so simple just to run to court and change the policy that way. There are a lot of questions that go into why litigation hasn't been as much the way that this has been attempted.
Sorry to jump in. John, this is Janelle at the Law Center. We're actually not seeing your slides advance.
Oh, I am sorry that's the case. Maybe you should actually take control back and we'll skip to where I am in the presentation.
Okay, I'll do that. Thank you.
Thank you.
Absolutely.
This is where we were. Okay, so the next slide will be where we've just come to. So there actually has been a little bit of litigation in Massachusetts on this issue, which again I don't really want to take a lot of time to talk about, except to say it's very complicated, and there are questions in the criminalization of homelessness context. There are often questions about what happens if someone has a pending criminal case at the same time as an eviction. Does that make their right to counsel argument for their housing case better or worse? That's being explored right now, and we'll move on from that. I just wanted to mention that it is out there as something that's being worked on. So what I wanted to talk to you a little bit about today is the policy work that's being done and the research that's being done to explore advancing the right to counsel. So the big one right out there right now is in New York City with a bill called Intro 214A, which has been pending for about 1.5 years and actually finally had its first hearing this past September. And this bill basically would actually provide a right to counsel, basically an eviction and foreclosure for low-income people. Originally it was at 125% of the poverty level, then it was raised to 200%. There are a lot of provisions of the bill which we don't have to spend a lot of time talking about, but it's been a huge effort in New York City. It's if you can go to the next slide, we'll talk a little bit about the support for the bill. The amazing thing about this bill, it has a veto-proof majority of the city council. It has the support of the city comptroller, the former chief judge of the New York court system. The mayor has not yet signed on to the bill because he's worried about the cost. But one of the things that we've done is we actually worked with an independent financial analysis company, and they produced a report saying that even after accounting for how much it would cost to provide lawyers for all these people, that the city would save $320 million a year if it were to actually provide a right to counsel. And that's because primarily of the shelter savings, of keeping people out of shelter. New York City spends over $1 billion every year on shelters. But there are also other costs in New York City. Every time people are evicted from rent-stabilized or rent-controlled units, those units are lost to the city, and then the city has to replace them, which is a significant cost to the city. So basically keeping those units affordable by avoiding evictions is a very big cost-saving win for the city. So basically the mayor has said he's considering the bill. He's not sure yet where he is on it. But I will tell you that as the result of this right to counsel bill being filed, and because of the incredible pressure that's been brought on upon the mayor has increased the city's investment in eviction defense representation by $60 million. That's a lot of people attribute to the right to counsel bill that was filed. That basically the bill put pressure on the mayor to basically do something to move towards that goal of providing a right to counsel, and he's done so. And there's been a tremendous outpouring of support. If you go on to the next slide, I've got a couple of examples of some of the media. This was a story in Newsweek that was done about this bill and tied it to the larger right to counsel movement. If you can go to the next slide. This was another one about that touched on the bill and basically the national movement for right to counsel. So this housing bill really got a lot of major attention. Next slide, please. So at the same time that New York City is considering this bill, there was actually a bill also filed at the state level in both the Senate and the House that was very similar to New York's bill. It provides a right to counsel in eviction and foreclosure proceedings. It is very detailed in terms of how it would be implemented. That bill has been stalled, and there hasn't been pressure to advance it because of the work in New York City. New York City is such a big part of New York State's housing problem that basically the desire was to focus on New York City first and see if we can get that under our belt, because if it were to happen, the cost of the state bill would go down dramatically, since the city bill would be funded through city funds primarily. Next slide, please. This was just a little bit about the, from the New York State bill, this is a little bit of the legislative sort of history or the legislative statement of purpose. And it says the benefit of adequate housing goes beyond stabilizing and improving the lives of working and middle-class families. It saves all of us money in the long run. It's a human rights crisis. There's really great language in the preamble sort of justifying this bill. So it's really great stuff. Next slide, please. This is more about how the program would work. It's got compensation rates and so on. We don't need to go into a lot of detail. As you can see in the slide, there was a bit of a discussion about who was going to pay for it. There were different versions of the bill saying, oh, it's the county, oh, it's the state, or it's both. And we don't need to go into those details except to say that, as you can imagine, the who pays for it is often the big question with right to counsel, especially who's going to pay for it at first. Next slide. So Massachusetts also has been considering right to counsel housing legislation, this at the state level, and it actually was proposed as an emergency law. Basically, it basically said this is a crisis. We can't afford to wait any longer. This bill got sent for study this year, so it means it's going to come back in the future with some study results, and it's going to come back in 2017. So we're looking forward to seeing what happens in Massachusetts. Next slide. Just like the other bills, it has some scope issues set out. It's set at 125% of the poverty level, or those who are unable to pay for an attorney without losing what it calls the necessities of life. That's a very unusual approach for legislation to sort of leave it open like that. Next slide, please. And lastly, on the legislative front, this year actually a bill was filed in D.C. called the Expanding Access to Justice Act, which basically would provide expanded representation in areas that are listed here: evictions, affirmative code violations, housing subsidy terminations. So basically listed, it said we're really concerned about these kinds of proceedings. In particular, we're going to expand housing representation. It's not a right to counsel per se. It's a funded project. When the money runs out, then there's no more counsel provided. But basically, the stated goal of the bill is, it says in the preamble, is to move DC towards a right to counsel. This is considered the first step of getting there. It provides a mixture of different services as far as what the provision would look like, and this bill is still pending at this time. So besides the bills, the other sort of area where the right to counsel movement in housing is looking is basically to research. The best way we can convince legislatures and courts to do this is to really have a concrete sense of both the exact impact it makes in terms of outcomes as well as the cost. And so to that extent, there have been numerous jurisdictions that have basically been funding efforts to increase representation in housing cases and then measure what the impact was. So you can see here, California has been doing it now for about 4 years. DC has been doing it for about a year. Massachusetts has done 2 rounds, the first that completed in 2012, the second one completed last year. And San Francisco has kind of an ongoing project. What's really exciting about this, you can see, is some really significant investment by city and state level government. DC and San Francisco, or excuse me, San Francisco at the city level, DC and Massachusetts at the state, / territory level, and California at the state level as well. This is really a fertile area to look for the future with state governments and city governments investing in the research we need to basically make the case for a right to counsel. Next slide. So if you want to keep up basically on what's going on, there's a lot. We basically track all of this work nationally. If you go to our website, civilrightstocouncil.org, all these states you see lit up in orange here basically mean there's something going on with them. It's not necessarily housing, because we do work in a lot of different subject areas, but if you click on the state, you'll see precisely what's going on. If you go to the next slide, it'll give you an example of what would happen if you clicked on a state. So that's basically like, that would be if you had clicked in Connecticut, that's what it would look like. It'd pop up a little thing, and you could click on any of the developments to see more. If you look on the screen, you'll see it says Right to Counsel status. If you click on that, you can see the Right to Counsel that exists or doesn't exist for every state, for every civil subject area there is. If you were to go to housing, you'd see there's very little. There's actually very little on the housing front there, because there's currently no jurisdiction, not one, not city nor state, that provides a right to counsel in housing cases. There are a few that provide it for very, very limited circumstances in housing cases, but the vast majority don't even authorize appointment of counsel at all. So that we clearly have a lot of work to do in advancing this issue, but the presence of these bills at the state level and the city level is really significant, because this is not an area that we've seen bills like this in the past. This is really a development that's happened in the last 5 years. That plus the city and state funding of research, also a very new development, I think, showing the increased interest in both housing and in the right to counsel, and the crossover between the two, and the criminalization of homelessness, and the increasing awareness of the criminalization of homelessness. I think making people say we need to do something to stop this. It's not humane. It violates people's rights, their human rights, and as was said before, it's not cost effective to do so. Providing lawyers is significantly cheaper than dealing with all of the consequences of allowing people to lose their homes. I think that's my last. Oh yes, one last slide. We also do have, and I apologize that the slide doesn't show housing, but if you were to go to our website and to our bibliography, there is a bibliography section for every subject area, including housing. If you were to go to housing, you would see, similar to what you see here, it would be broken down by cases, media coverage, the pilots, meaning the research projects, all the studies and reports we have on the housing front that relate to the provision of counsel in housing cases. So this is all on our website, and I encourage you to go there. These are some resources we often tell people about with respect to why the people who have written about why there needs to be a right to counsel in housing cases, either foreclosure or eviction. People have made really compelling policy arguments and human rights arguments for it, as well as some study data as well. So I think that's all I want to say, but I'm glad that to again have the chance to talk about how the right to counsel fits into alternatives to criminalization of homelessness.
Thank you very much, John. That was a lot of great information. Please do follow up with the resources that John has mentioned if you're interested in learning more about the right to counsel. The bibliography in particular looks fantastic. So returning to the methods for promoting housing as opposed to handcuffs. And one, obviously, is to increase access to affordable housing. Some of that, again, means finding new and additional funding for affordable housing development and rehabilitation. So first, I wanted to talk very briefly about the National Housing Trust Fund, which is federal government money that is represented in the form of a HUD block grant to states that is not subject to the annual appropriations process, and instead is funded by profits made by Fannie Mae and Freddie Mac that go into a fund that is administered for the purpose of developing and rehabilitating housing that's available to extremely low-income households. And what that means are households that in total earn 30% or less of the area median income. In 2016, HUD announced that it had $174 million available through the National Housing Trust Fund, and there have been efforts in Congress to provide additional funding into the National Housing Trust Fund. There are also other ways to develop dedicated revenue sources for expanded affordable housing. or services. And one example is the Miami-Dade Homeless and Domestic Violence Tax, whereby a 1% tax on certain food and beverage sales within the county of Miami-Dade go into a fund that provides around $20 million a year to the Miami-Dade Homeless Trust, which then funds homeless housing and services in that county. Beyond, and there are also a number of state housing trust funds as well that impose percentages of document recording fees and other types of real estate transactions that can produce dedicated funding streams as well. And for more information about that, please check out our website. Beyond additional funding, it is important to look at zoning laws in a given area to see how they may inadvertently be restricting development of affordable housing. For example, there may be density requirements or parking restrictions, height restrictions that can prevent the development of additional affordable housing. So reviewing those laws and eliminating or reforming them where possible is another strategy that local governments can use to expand the ability to affordably grow the affordable housing stock in the community. Inclusionary zoning policies are ones that can either incentivize or require developers who are building new housing in a given area to include affordable housing units as part of that development. And to be most effective, inclusionary zoning laws should be mandatory. There should be units made affordable to those earning, again, 30% of area median income or less, and it should be kept affordable for the long term. And to create the necessary incentives for affordable housing development, in turn, what cities can do is offer either expedited permitting or density bonuses or otherwise incentivize affordable housing developers who may not have included affordable housing development in their planned development. In addition, it's important to remove barriers to rental housing access. Sometimes homelessness is a result not of a lack of ability to afford a unit in a given area, but instead the lack of ability to access the few affordable housing units that are available in a given area. Sometimes that can come in the form of discriminatory practices. For example, source of income discrimination is common across the country. When I refer to source of income discrimination, I am referring to a landlord's refusal to rent to someone because of the perception about the person based on their legitimate source of income. The most classic example of this would be someone who holds a Section 8 voucher may have difficulty finding a landlord willing to rent to them because they do not wish to rent to the quote-unquote type of person who receives a Section 8 voucher. So one way to address that type of discrimination is to enact and implement laws that reduce or outlaw source of income discrimination. Next slide, please. Finally, aside from dollars, there are other resources that exist right now in communities across the country that can be put to better use. And one great example of that is vacant property that can be turned from being unproductive to productive use on behalf of homeless people. And the federal law that has been in existence for 25 years that allows for surplus federal property to be used for homeless housing and services is Title V of the McKinney-Vento Homeless Assistance Act. The Title V program allows homeless service providers, and that can include state, local governments, or nonprofits that provide eligible services, with a right of first refusal to unneeded federal property. This means, as a practical matter, that property is held for a period of 60 days for an interested homeless service provider to express interest in applying for title or long-term lease opportunity to use the property for its programming needs. And critically, the property is transferred from the federal government at no cost for the title or for the lease to the homeless service provider. There are thousands upon thousands of properties that are in the real property holdings of various federal agencies. And when they are unused, that represents not only an opportunity cost, because that space can be put to better use, but also the overhead cost of maintenance of these properties wastes millions of taxpayer dollars each year. And so transferring properties that the federal government does not need and putting them to productive use at the hands of a state, local government, or nonprofit who can use it to address homelessness in their communities is a really fantastic use of the property. And the Law Center has assisted applicants over the course of 25 years. And today, over 2 million people are served in properties that have been transferred pursuant to the Title V program in over 500 buildings, 900 acres of property in over 30 states. Recently, and by recently I mean on Saturday morning, a bill cleared Congress that will reform federal real property disposal, including disposal of properties under Title V of the McKinney-Vento Homeless Assistance Act. What these reforms will do is improve transparency into the government's federal real property holdings, streamline the ability of homeless service providers to successfully apply for these properties, and it also expanded the use that these properties are eligible to be transferred for. Most notably, permanent housing, even without supportive services, is now an eligible use. So federal properties that aren't needed can be turned into permanent housing for the homeless population in your community. If you're interested in learning more about the Title V program, please do contact the Law Center. We provide technical assistance as well as monitor implementation of the Title V law, and we can help you search for properties in your area which will, pursuant to the new legislation, be listed on either HUD or the General Services Administration's website. Other uses of vacant property are found in the Illinois Abandoned Housing Rehabilitation Act, another example of turning unproductive property to productive use. In that instance, that state-level legislation allows nonprofits to take control of abandoned homes that were privately owned, rehabilitate them, and then if within 2 years the former owner does not attempt to receive title to the home, and if they do, then the nonprofit is compensated for their investment into rehabilitating the abandoned home, then title to the abandoned home is transferred to the nonprofit. That has allowed for expanded affordable housing available in Illinois, but also it has improved the quality of life in neighborhoods that had blighted, vacant, abandoned homes that are now turned into occupied, rehabilitated homes. So that's another example of how surplus property can be used. And we touched again we touched before on the Navigation Center in San Francisco, but it bears repeating that this is an example of a city using vacant California school property to turn that empty building with a private grant into a low barrier shelter in which is the Navigation Center in San Francisco. And you'll recall that the Law Center has promoted the Navigation Center as a good example of a low barrier shelter, which means a shelter whereby people can come as they are. There are not the fairly common sobriety requirements. There are not gender restrictions. In fact, males and females can reside together in the same rooms that are converted classrooms. They can come with their pets, and they are quickly paired with permanent housing opportunities from their placement at the Navigation Center. And also critically, there are no curfews that apply to the Navigation Center. People are able to stay there day after day with their belongings and are not subject to unnecessary curfews that can make the shelter inaccessible. They have had a very high success rate in placing people into permanent housing, and the Navigation Center that was originally sited in a school is being expanded to a total of 6 locations in San Francisco, and the city of Seattle is looking at adopting a similar low barrier shelter model, and perhaps may use vacant property to do so. So, those are dramatically underused assets that could be turned to productive use, and we're highlighting just a few of the laws that exist now that can help enable that, or that can serve as models for legislation that can assist your community. Next slide, please. So at this time, and I appreciate those of you who have stuck around. I know we're over time. We have just a couple of quick survey questions. And again, these survey questions are ones that we ask so that we can improve the content that we deliver to you. We want to know whether this information has been helpful, and also what you'd like to hear more detail about moving forward. So with that, I'll turn it over to Janelle Fernandez. If you have any questions, of course, feel free to contact me. My contact information is on this slide.
Thanks, Tristia. Hi, this is Janelle Fernandez at the Law Center. You should see on your screen right now a survey question that we would greatly appreciate if you could just give a quick answer to. You can respond just by clicking on the window on your screen. We're asking, did this webinar improve your knowledge of constructive alternatives to the criminalization of homelessness? And you can choose yes, a lot, yes, a little, or no, not really. And knowing this information really helps us to tailor our webinars to make sure that we're presenting information in a way that's useful to you. So I will give just a few more seconds for folks to vote. About half of attendees have voted so far. And while we're waiting, I'll just note that we're going to do just a real quick Q&A session in a minute. So if you have additional questions, you can type those into the chat box, and we'll come to those just after these survey questions are complete. All right, so I will share those results with you. So asking, did this webinar improve your knowledge? 56% of folks said yes a lot, 44% said yes a little. So that's great. We're glad to hear that this was helpful to you. And I have a second question for you. So you should see this one on your screen now. Will you use what you learned today in your work or in your advocacy? So your options are yes, no, or not applicable. And this is really helpful for us to know the impact and how frequently this information is being used with the folks that we're sharing it with. So we have about half of people voted so far. I'll give just a few more seconds. All right, and I'll share these results with you. 95% of you said yes, you will use this in your work or advocacy, which is fantastic. We'd love to hear that. It's great to know that this information is being put to good use. So thank you for that. And now the final question before we move on to Q&A. Which of the topics covered today would you like to learn more about? The options are inclusionary zoning, using vacant property, just cause eviction laws, Right to Rest Act or Homeless Bill of Rights, and source of income discrimination. And you can choose more than one answer to this question, and your responses to this will help us determine what topics to cover in future webinars that we provide. So I'll give just a few more seconds for folks to answer that. We're at about half of responses so far. Okay, great. So let me share those results with you. The two big winners here were Right to Rest Acts and Homeless Bill of Rights, and using vacant property. So all of the topics there show a lot of interest from folks on the webinar, but those are the two that got the most attention. So we will keep that in mind as we plan our future webinars. So with that, I will jump to Q&A, and as I am looking at the questions submitted there, I'll just take the opportunity to answer a frequently asked question, which is, yes, we will make the slides from today's presentation as well as a video recording of this webinar available to everyone. An email will go out to everyone hopefully later this week with links to the videos as well as where you can download the PowerPoint presentations to review later. So with that, I have a couple of questions to pose to Tristia and John. The first is, there was some discussion of cost studies earlier in the webinar. The ones that were presented, are those the only cost studies that we're aware of, or are there others?
This is Tristia. There are a number of cost studies. We chose to highlight just 3 in this report. We highlighted other cost studies in our prior No Safe Place criminalization report, and there are studies that have been growing such that the Law Center will be producing a cost study summary as well as suggesting a cost study design methodology for people who are interested in establishing with data relevant to their communities that criminalizing homelessness is considerably more expensive than ending homelessness through housing.
And this is John. The New York City cost study is not the only one that's been done. It's probably the most systematic and comprehensive, but the other ones that exist can be found, again, in our bibliography section in the studies and reports area for housing. What cost studies have been done are in there.
Great, thank you both. Next question, do either of you have suggestions for counties or local areas that have adopted a housing first strategy, but there's just no housing to go around?
Well, so one of the kind of initial things would be to maintain the housing first strategy. I mean, as a strategy that works, of course, it's not ideal when you can't employ that strategy due to a lack of resources, but it could be a good idea to enumerate what the strategy includes and to put that into a written policy or statute such that when resources do arise, the use of housing first models can be immediately employed with some guidance for those folks who are still new to the idea and new to the implementation of housing first strategies. I'd also encourage people to think about housing first more broadly than just being applicable to permanent housing. It's always been discussed in that context, but it's always strange to me when I speak with communities, and I speak with a number of them, where it is literally harder to get into an emergency shelter that offers shelter for a single night or into a tent city, for example, than it is to get into permanent housing. So housing first principles should be more broadly applied to all homeless housing and crisis interventions such that people can be brought in as they are to a stable place to live, be connected with services, and eventually end their homelessness.
Great, thanks, Tristia. Okay, next question. How can folks learn more about Title V, the surplus property program that was discussed near the end?
Great. Well, as I mentioned, the law was recently reformed, and so the Law Center will be releasing a toolkit that functions something like a Q&A to help prospective applicants know what they need to do in order to successfully identify and apply for properties under the new law. But in addition to that, we have existing resources that are available on our website now. For example, there is a report entitled "This Land is Your Land," which was released in 2012, but is still relevant in that it provides a general overview of the Title V process and, perhaps more importantly, lists out a number of programs that are successfully operating in Title V properties currently. And that can help communities get a better understanding of the really wide array of uses that are available under that federal law.
Fantastic. Thank you both. So there's a few additional questions that we'll try to answer via email, but I will just encourage folks that have additional questions or want more information to reach out. Tristia's contact information is on the screen, and I will pass it back to you, Tristia.
Thank you very much, everyone, for attending. We will be doing more regular webinar series related to our Housing Not Handcuffs campaign. I'd encourage everyone who is listening to this webinar to check out housingnothandcuffs.org. Endorse our campaign, which stands for the principle that housing, not handcuffs, ends homelessness. Please take a look on the Law Center's website and check back on the Housing Not Handcuffs website for tools that can be helpful to your advocacy in local communities. Please take a look at the websites of the partner organizations that we're working with to end the criminalization of homelessness and promote additional housing options and opportunities in the country. And thank you all very much for joining us today.